ओके हाँ बात आप ठीक है Okay, good morning, good afternoon to all of you. Welcome back. I hope you are uh, in memory of who I am and what course we were discussing together. Please let me know if the audio and visual is clear completely to you. Let me know, class, if you can hear and see me properly. Just give me a cue that you can hear and see me properly. Class, let me know if you're there. I can read the chats. Please let me know if you can hear and see me properly. Okay, great. Cool. Nice. So, okay. First of all, before we go on, we had discussed a lot of things in the last part of governance when we were dealing with it. And one of the things was about the disqualification of MPs. Remember that? Right? We read a lot about disqualifications. And we had taken a particular case of a member of parliament from the Wayanad constituency being disqualified. Right? And I had left the matter at what you can call that the Gujarat High Court had to give an order. I gave you the date that 7th July, Gujarat High Court is going to give the order in which the request made by the MP was rejected. Right? And the MP has taken the Gujarat High Court order and appealed it in the Supreme Court. And Supreme Court has had one hearing of it, and the Supreme Court has put the matter up for another hearing on the 4th of August. So I hope that you have been able to, in a way, sense the point at which this kind of a thing is arriving logically. Were you able to follow the news article? Were you able to relate to it? Were you able to step by step understand exactly what the Supreme Court was saying with regard to all that we had covered, section 499 and section 500 of the IPC, and section 8, subsection 3 and subsection 4 of the Representation of People's Act? Remember that? So the question that I'm asking is that were you able to get a sense of what we were trying to, understand in the classroom, and were you able to make a point about how what we were discussing in the class can actually help you in understanding the current affairs as they develop properly? The fact that we had taken a look at this very closely. So when this whole thing was happening in the recent times in the newspaper, the question that I'm asking that were you able to follow it up? Tell me. Were you able to follow it up in terms of understanding it clearly in your own point of view perspectives? Any observations from this particular development? From the Representation of People's Act, any observations that you would want to share with me or you had an understanding of? Okay, let me just open the Representation of People's Act again. So were you able to make some sense out of that news item, the rejection of the High Court and the appeal to the Supreme Court and the contests which has been raised before the Supreme Court by the MP from Wayanad in this kind of a situation? Okay, just let me refer to one other article which was in news with regard to this, one other section of the RPA which was in news regard to this, section 151A. Okay, this was another section that I think I was hoping to cover with you once the news was out. So take a look at this. Take a look at section 149, just a little bit of an addition to what we had studied last time to kind of cover the entire set of current events that we were dealing with. Section 149 of the RPA states casual vacancies in the House of the People. When the seat of a member elected to the House of the People becomes vacant or is declared vacant, or his election to the House of the People is declared void, the Election Commission shall, subject to the provisions of subsection 2, by a notification in the Gazette of India, call upon the parliamentary constituency concerned to elect a person for the purpose of filling the vacancy so caused before such date as may be specified in the notification. Right. So what basically it means is that if a house has a vacancy which has been created because of a election being declared void or disqualification or any other sense, vacancy happens, then the Election Commission of India is supposed to conduct what are known as by elections. That is what is given in section 149, right? And then you have section 151A, which states that time limit for filling vacancies referred to in section 147, 149, 150 and 151. Okay, so when we think about this perspective about the time limit, let's read this out. Notwithstanding anything contained in section 147, section 149, section 150 and section 151, a by-election for filling any vacancy referred to any of the said sections shall be held within a period of 6 months from the date of the occurrence of the vacancy. Okay. Now, when, for example, when you had the council who was arguing for the member of parliament from Wayanad, he was saying that if the Supreme Court does not act in a kind of a quick manner, it is possible that once the 6-month period is crossed, the date upon which it was argued before the Supreme Court, the counsel Abhishek Manu Singhvi said to the Supreme Court that he's already spent 112 days as a non-member of parliament, as disqualified from the member of parliamentship. Okay, so he said that to expedite the process, we have to make sure, meaning what he says that to not let an injury or a harm happen to any person, they have to ensure that the member of parliament is restored and the Supreme Court takes up the matter in a speedy manner, so that you don't have a cause or a case by which the by-elections are organized in that particular constituency, and these by-elections may give result to another person coming in place of the member of parliament from Wayanad, right? So 6 months period was something which was referred to in this particular case. Supreme Court has taken note of all of this, and Supreme Court has not given any interim relief to anyone at this point of time, but it has given the next date, which is the 4th of August, when the Supreme Court is going to hear this pleading again. The last date upon which it was heard was 21st of July. Okay, so from 21st of July, we have the next date coming on 4th of August. So you have to keep a track upon this kind of a development as it happens over there. Clear? So that's a point that I'm trying to make over here, that you have these areas and aspects which are going to be of relevance, right? So you can add two sections over here to what you have written in the Representation of People Act. Section 149, which talks about by-elections, and section 151A. Section 151A, which talks about the time period within which by-elections must take place. You see the point? Section 149 talks about by-elections. Section 151 it talks about time period within which by-elections must take place, right? And that is given as 6 months from the date of vacancy. From the date of vacancy. So I request all of you to, in a way, take a look at the notes that we had written on the Representation of People's Act and add these two sections also to your coverage, which is what we are talking about, section 149 and section 151A, which were mentioned before the Supreme Court in this particular thing, right? So we'll be open to looking at what the Supreme Court is saying on the 4th of August with regard to this particular matter, right? You get the point? Okay, so just add this, what I've written on the board, section 149 and section 151A, write all of both these points in addition to what we have written over here, please. Yes, so Subhashri, I hear your point. Recently, you came across an editorial which was indirectly mentioning, yes, this is a valid concern raised by a lot of people, that the judgment of the Gujarat High Court was a little inconsiderate. But let's say we have to wait for the Supreme Court to take a judgment upon that. The editorial pieces are themselves not sufficient to get a point about what we're trying to do. Okay, okay. Let's just take a look at some of these articles. Okay, here's an article which came on July 21 after the Supreme Court had heard the case. Let's take a look at what is it that the Supreme Court was saying. We'll read this current update. You can add this. I have made you leave 3 pages around that area as you are mentioning. So you can add one of these parts over there. The Supreme Court on Friday issued notice to complainant Purnesh Modi and the state of Gujarat in a petition filed by Congress leader Rahul Gandhi seeking a stay on his conviction in a criminal defamation case. A bench led by Justice B.R. Gavai, etc. So the court said, a request was made by senior advocate Abhishek Manu Singhvi, etc., for an interim suspension of the conviction, but it was refused by the judges. They say at this stage, without hearing the other side, how can we provide an interim, suspension of the conviction? Mr. Singhvi then pressed for the need to the shortest possible date for the hearing, he highlighted the need for an urgent hearing of the case as 111 days had already passed since Mr. Gandhi's disqualification from the House. He has already missed one session and is unable to participate in the ongoing monsoon sitting of the Parliament. When senior advocate Mahesh Yatmani objected, Mr. Singhvi says, your clients needs to be bothered only about the conviction part and not disqualification part. Okay, Mr. Singhvi said the by-elections for the Wayanad, the constituency, may be announced anytime. There was a constitutional mandate under Section 151A of the Representation of People's Act to not allow the vacancy of a seat for more than 6 months. Right. So this is what basically it was said. The next hearing is fixed at 4th of August. By the 4th of August, you will have all the newspapers filled with the updates upon what the Supreme Court has been saying in the matter. Okay, and also please keep in mind that as we are speaking, the monsoon session of the Parliament is currently in process. Even today, the Parliament is sitting, both the Lok Sabha and the Rajya Sabha, and there are 31 bills tabled before the Parliament to discuss in this specific session. So, just to put that in context with what we're trying to understand here is the fact that the government and the MP are going to contest this kind of a system before the Supreme Court. Okay, I hope that kind of clarifies what I'm trying to say over here. ठीक. Now, just help me out, please. Uh, can you identify for me what was the last thing that we were covering in the governance part before we had moved out? Before we had taken a break last time, what was the last topic that we had covered in the governance subject? Some one answer that I'm getting to that is section 3 of the RTI Act. Okay, we had covered. Please confirm if this is what we had covered. Section 3 of the RTI Act. Was this the last thing that we had covered? Is this the last thing that we had covered? We were taking a look at accountability, I remember. Accountability and transparency. So, can you give me a bit of an understanding of what was the last thing that we had covered over here, please, class? Just pull out the Right to Information Act for us to read. So, have we covered section 3 and section 4 also? I feel we have covered or not? Okay, in any case, let me just resume from that point. I just wanted to mention the current updates upon the Member of Parliament from Wayanad constituency case, but let me just go back to the RTI Act. Okay, just to put everything back in context. When we are taking a look at RTI Act 2005, we've understood the historical background of the RTI Act. We've understood about the Mazdoor Kisan Shakti Sangathan and the movement for the right to information in Rajasthan, which kind of exploded and became a national movement and eventually culminated in the enactment of the RTI Act in 2005. We've taken a look at this properly, and we had also understood how the Supreme Court, for example, had already mentioned the concept of RTI in different areas in different versions. So, that's one of the features of what we are taking a look at with regard to RTI. In addition to this, let's take a look at something more significant, which is the RTI Act itself. Okay. So, I must have mentioned section 3, which is the right to information itself. Here, RTI, we are dealing with RTI Act. A right to information, subject to the provisions of this Act, all citizens shall have the right to information. Right. So, over here, right to information is guaranteed to all citizens as a statutory right. RTI is a statute, and the right which is guaranteed under this RTI Act is the right to information. which is now it becomes a position of a statutory right. Okay. Obligations of public authorities. Every public authority shall maintain all its records duly catalogued and indexed. Let me, for example, just explain to you section 4. If I have explained it to you last time, please just let me do it again in case there is confusion. Section 4 says very simply this thing. Now please follow me as I'm saying it, right? And I am expecting you to keep a running set of notes to be jotted down on your notebooks while we're dealing with this kind of a thing, okay? Okay, so you take a look at section 4 and what we are taking a look in this particular aspect is this thing, that let's say you have first of all the concept of a public authority. That is what is given in public in RTI. Like public authority, that is a term which is given away. Right? Now public authority can have two meanings. One meaning that public authority can have is that an authority which is controlled and owned by the state. Okay, this is the meaning of public authority. An authority which is controlled and owned by the state. Right? So, for example, if you have, let's say, the Reserve Bank of India. The Reserve Bank of India had come into being by the RBI Act 1934. So, it is a statute which gave birth to the Reserve Bank of India. Okay. Similarly, for example, if you have the Niti Aayog. Niti Aayog came or was born by what you can call a cabinet resolution. And therefore it is an executive act. So this is a definition of a public authority, is an authority which is controlled and owned by the state, or what you can say, which is given birth by the state. That is one definition. So all the organizations in the government of India, or let's say which are born out of the government of India, you have, for example, the PSUs like BHEL, NTPC, then you have CBI, then you have CVC, you have CAG, all these plethora of organizations which have been born out of the government of India, which have been born out of the state has given birth to them, are covered under the right to information. Right? Number one. And then public authority has another meaning, that any body which may be involved in any kind of a public function. Okay, let's say for example, if there is a Tata Power. Tata Power is a private company, but it supplies electricity. It is in the business of generation and supply of electricity. Okay, this is what basically a company is. But since electricity has been considered many times to be a public good, it is possible to involve this kind of a thing also under an RTI, because it is something which is happening by the public, for the public and of the public. So electricity is such a huge commodity, it cannot be monopolized by the one who is generating it, and it is impossible to have that kind of a business without the cooperation of the political powers, the public involvement of doing things, right? So therefore the fact is that in the Supreme Court can, for example, make certain public functions which are being taken by private organizations also a part of the RTI. However, it does not happen too much or too often, and RTI in India is more or less limited to only this, an authority which is controlled and governed by the state. Okay. So, for example, when we take a look at the RTI Act, section 3, we see it says that every public authority that is a term which is used over here, every public authority must maintain all their records in proper index and catalog. Matlab the records which have to be maintained by a public authority have to be properly indexed and cataloged. They have to be properly furnished and documented nicely in simple language which can be understandable by anyone. Okay, so that it is accessible under the RTI, which makes the person who is getting information under the RTI very simply read the entire language of it. You see, the point that we are trying to make is this, that for example, let's say you have the government organization, let's say for example, there is a municipality, and the municipal commissioner and other people, for example, is uh, looking for, let's say, is involved in some kind of a corruption of some money which is coming from the finance commission recommended authorities from the central government. The If the municipal commissioner, let's say for example, is engaging in corruption, he can try to hide the corruption by, let's say for example, document the entire thing in a code like structure. Let's say for example, he says that for the purposes of convenience we have developed a new shorthand. Okay, for the purposes of convenience we have developed a new shorthand language. Okay, and let's say he has used the term VCNC again and again in some document. Okay, now he says that in this document what VCNC stands for is vaccines, but actually it stands for vacancy. You see, so you can create a kind of a manipulation of the document by coding it properly, and then say that this is just a understanding which is originating out of the particular language that we use. We are not involved in any kind of a corruption. That cannot be made an argument, because the government has to keep every document catalogued and indexed in such a manner that it can be accessible to every common man, and it does not have any kind of a confusing way of writing things. You see the point? So abbreviations, short forms, sign languages, all of these things cannot be used. No attempts can be made by the public authority to do a kind of a thing by which the document is not rendered to be uniform and standard and readable by every person according to standard ways of understanding the reading of the document. Okay, then it also talks about digitization. It says that the as soon as possible, digital copies of all the government documents must be created by public authorities, and this must be put on a national network. Okay, so this whole idea about कि बाढ़ आई और सारा document जल गया, मतलब बह गया बाढ़ के साथ, you had a flood and by the flood only all the documents went away, everything was taken out by a kind of a natural catastrophe. So it talks about putting all the documents in digital formats on a computer network on a kind of a centralized data structure. NIC, sometimes you may understand this, National Informatics, is basically where all the standard database can be maintained by the government of India. So you have to ensure as a public authority that you put all them in digital format and then upload it on a kind of a data center from which it can not only be accessed by you but all the people who are involved in this particular thing. Let's say for example, if you have a national bank like a Punjab National Bank, and Punjab National Bank does one kind of a loan agreement in the city of, let's say, Patiala, then this document must be uploaded to the PNB national server, and all other branches, let's say you have one branch in let's say Delhi, you have one branch in Kolkata, all these branches, if it is allowed to them, can access this information from a standardized network from which this information can be taken up properly. So that is what section 4 of the RTI Act says. If we have not covered section 4 previously, please take a look at this part. Section 4, subsection 1, subsection A. Please take a read at it very simply. Okay, you get the point. So, public authorities maintain all its records duly catalogued and indexed in a manner and the form which facilitates the right to information under this Act, and ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources, computerized and connected through a network all over the country on different systems so that access to such records is facilitated. This is what is talked about by Section 4 of the RTI Act. Are we going with proper clearance on this? Okay. Yes, yeah, I understand, Viswajit, the point about Manipur. I'll come to it. Trust me, we have classes remaining. We will discuss Manipur properly. Don't worry about it. Um, Anil has a good question, which is a very good observation from the recent current updates that you have a data protection bill which is being tabled before the parliament in the monsoon session. And this news is saying that some amount of provisions of the data protection bill are controversial because they are diluting the RTI Act a little bit, right? Even in fact, the Mazdoor Kisan Shakti Sangathan, which is the organization which was responsible for starting the social movement which led to the RTI, itself has said that certain provisions of the data protection bill will make the Right to Information Act very, very weak, meaning the ability to get information very, very weak. So, we'll take a look at what all that is. I'll keep it in mind to update you on that. It's a very good observation, Anil. Thanks for being vigilant about this. Good. That's a nice citizen initiative that you have very clearly taken out. Okay. Good. That's a good one. So I'll come to all this very clearly. Section 3, Section 4 are we clear about? Okay. Section 4. All right. Now we move to what is the next section that we have to deal with the RTI? Are we dealing with Section 5? Section 5, very simply, Section 5 talks about public information officers. Okay, so let me just very quickly lay out to you what is the point about a public information officer. Okay, I'm going to make a simple chart about it. Let's say, for example, think of it like this. Let's say this is a kind of a what you can call what is simply known as a hierarchy of commands. Okay, this is a hierarchy of commands within a government organization or what you can call public authority. Okay, let's take for example a simple one. This is, let's say, a government school, right? It's a school till 12th standard and it is completely funded by the government of the state. Let's say government of West Bengal school, right? Any sarkari school. You can take the example of a Kendriya Vidyalaya or a Rajkiya Vidyalaya, any of that, right? Let's say we're taking the example of a Rajkiya Vidyalaya, state sponsored school. Okay. Now, let's say the top of the school is the principal, and then before under the principal is the vice principal, and then the next in position are teachers who are of the lecturer grade. Okay, these are the lecturer grade teachers. Okay, and then lecturer grade teachers for their own subjects have assistant teachers. And let's say one of the assistant teachers has, let's say for example, a lab assistant, one who, let's say for example, this is an this is the let's say HOD of biology in the school, okay, and then there is an assistant. There are two assistant professors under her, and one of the assistant teachers has one lab assistant under her, and let's say the lab assistant has two, uh, let's say one peon and one clerk who helps him out maintain a laboratory. The biolab is maintained by this kind of a thing. You see? So let's say this is a very simple typical hierarchy by which a government organization is organized. You see, you can do a similar kind of an understanding of any government organization. You take a bank, you take a telecommunication organization like the BSNL, you take a, let's say for example, even a government administration, for example, a collector's office, all of these would have this kind of a structure. Now, what basically happens is, let's imagine a situation in which we have to understand a particular fact. Let's say this teacher over here claims that the appointment of this teacher has been done by the principal through favoritism. Let's say she is due for promotion, but she is not being promoted because she has been uh, given the promotion instead of her, right? So all these were at the same level. She wanted the promotion, but she has been promoted, and she says, she thinks to her mind that there is favoritism, that for example there is some kind of a bribe involved, or there is some kind of a, what you call a kind of a, जिसको कहते हैं जैक लगा के काम कराया. You have taken the obligation from someone has sourced it, minister से बात कराई, कुछ कराया, etc. So let's say the teacher over here feels that she does not have the merit to be promoted, that she does not have the required qualification to be promoted. Okay, let's say she does not have a gold medal in biology, which is a, let's say, a requirement, and she actually has a gold medal in biology. Okay, so what you're going to be looking at is the fact that she will take a kind of a thing and try to find evidences against her, right? And for that, what she would require is information. She would need information to substantiate her claims, right? So what we are going to take a look at is, if you take a look at, for example, the RTI Act and Section 5. Section 5 states that any government office will have to nominate among its own members one of the members as a public information officer. This is what is the name of the term, public information officer, PIO. Okay. Now every government department is supposed to have a PIO, and the PIO is going to be the central point from which information can be demanded. So let's say for example, if she has to file an RTI, she who is claiming that her information has not been given to, meaning that her promotion over here is not according to merit, what she will do is she will file an RTI with the the public information officer, demanding, let's say for example, her mark sheet. She would say that you give me the mark sheet of her in terms of her BSc or MSc in biology. Okay. So what she would do is she would demand her mark sheet, and in the mark sheet she would get an idea that there is some kind of a discrepancy, some kind of a merit has been compromised over here. Okay. So what she will do is, if she is able to get the mark sheet and get a copy of it, she can go to a court using that mark sheet, and then court ke samne she can say that the merit in this particular promotion has been neglected for favoritism, and therefore this promotion shall be cancelled. That is how simply what RTI works. But for that, what you need is her ability to go to the PIO, the public information officer. So what it says is that every department, every public authority shall maintain a public information officer within itself. If you are a government bank and you are a branch of a government bank, for example, you are a branch of the State Bank of India, your bank branch must have a public information officer. Generally, it is a manager. Even in a school, the principal itself is a public information officer. Okay, so the highest post in a particular office is generally also given the charge of having the public information officer, and the public information officer is statutorily obliged under the RTI Act to look at the applications demanding information from that department, because obviously the principal will have all the documents, right? And if a letter comes to her demanding the merit score of this particular person who has been promoted under section 5, she has the statutory obligation to consider that application, right? So when we say filing an RTI, when we talk about that an RTI has been filed, okay, this is what we're taking a look at, right? Filing of an RTI. The idea of filing of an RTI implies that this person has taken the right to information application and sent it before the public information officer, PIO, right? So this is the most elementary level of authority which has been created under the RTI Act to ensure right to information. You get the point? Understood? That's the point we're trying to make. This is the elementary level of authority which has been created by the RTI Act, which has to ensure that there is right to information, which has all the information under its hand, and if it thinks that this information can be given under the RTI Act, it will make that information public. It will have to give the merit sheet to this particular person, right? I hope we understand this clearly. ठीक है? Are we sure about it? Okay. Now, another thing about the PIO is that within the PIO, let's say for example, you have this. There is a public information officer in PIO, right? Now, the PIO as a concept can be divided into two categories. Okay. If it is a central government office, let's say for example, if it is a Kendriya Vidyalaya we're talking about, then the PIO would be called a CPIO, which is the Central Public Information Officer, because that office comes under the central government. Kendra Sarkar ke samne wo office aata hai, right? Central Public Information Officer. This is what is the CPIO. And then you have SPIO. If let's say for example it is a school which is affiliated to the government of West Bengal and it is also with the West Bengal board, then the principal of that would be called a state public information officer, right? So you have the concept given under section 5 that you must have a PIO who shall be responsible for giving out all information or considering the right to information applications, and then it has the information and it has the ability to grant that information to the person who is asking for it. Okay. And another thing that the government has also, the act also says is that both the CPIO and the SPIO, if required, can have a assistant public information officer, APIO. For example, if it is a central government department, then it can be called a CAPIO, and if it is a state public department, it can be called an SAPIO. Okay, are we getting the point over here? This is the structure by which PIO can be organized, given an organizational way of looking at the PIO. PIO is categorized into two classes, the central PIO and the state PIO. And the act states that if the PIO cannot handle all the matters by herself, let's say it's a huge department, then she can create assistants under her. For example, in the previous case, if you have a PIO as a principal, right? But there's a lot of RTIs coming. So what she can do is she can appoint the vice principal or any of the senior faculties as assistant PIOs. Okay. So what they will do is they will help her. Let's say, for example, there are, let's say, 57 RTIs filed every day in that government department. So what will happen is that first all these RTIs will go to the APIO, and APIO will filter out the ones which are relevant, 15, to the PIO. So she would understand that a lot of these are non-serious or just, they don't have any point, etc., etc. So she'll write a response to them, ki you can't get this information, etc. And only the serious ones will be filtered out to the PIO. So this kind of a structure has been created to help the PIO to deal with information, and the PIO can have the assistance of the APIOs, right? That is basically what we're taking a look at when we talk about section 5 of the RTI Act. Can we please read it once? Please, section 5 of the RTI Act. One by one we'll knock it out. The entire Right to Information Act, we'll take a look at all the sections of it one by one, and you'll have a complete understanding of this thing. Okay, are we clear about it? Every public authority shall within 100 days of enactment of this act designate as many officers as the central public information officers or the state public information officers, as the case may be, in all administrative units or offices under it as may be necessary to provide information to persons requesting for the information under this act. Without prejudice to the provisions of subsection 1, every public authority shall designate office within 100 days for the enactment of this act at each subdivisional level or another, what you can call district level central assistant public information officer and state assistant public information officer. So this is a structuring that we have done. Now you see, as citizens, take a look at it as citizens. Okay, as citizens you have the ability. Let's say if you are dealing with a government department, let's say you're dealing with a college or a university or a bank or any, let's say if your mother or father is retired from a government department and they are not able to get their pensions easily. And then the question is whether there is corruption, whether there is deliberate delaying in doing the activity because they are expecting a bribe, right? All that you have to do is you have to locate that. Let's say if my father is retired from a bank and the pension is not coming for the last 4 months, and they're saying ki kaam chal raha hai, dheere dheere it's taking time, some due has happened, etc. The best thing that you have to do in this regard is just identify who the public information officer is. Go to any of those persons and say, I want to know who the PIO is, and tell them section 5 of the RTI Act entitles me to know the PIO, right? And when they will tell you who the PIO is, you write a application on RTI to the PIO. The PIO is statutorily obliged to consider your application with regard to why is it that your file with regard to your father's pension is not being given or given a kind of a headway. So they will give you the reasons as to what is the reason. मतलब आपने ये जमा नहीं किया, इस वजह से आपकी फाइल नहीं आगे आ पा रही है. They will give you a written documentation over it. Or if there is no reason for it, they will stand exposed that for no reason at all they are being, delaying things, which is a deduction that they are obviously looking for a bribe or some kind of a profit out of this entire thing. Okay, and once you have that kind of information, you can go to the media, you can go to the court, you can also go to publicly shaming these people, standing in the middle of the office and telling him, I have got this on paper, I can go in the court and sue you. You can create a kind of a moral pressure upon them to do your work. Information is extraordinarily important in fighting a battle of good governance. That gives you evidence which allows you to create all kinds of pressures upon the government. You see the point? And that's the whole idea about a Information Act system. Clear? So we take a look at the section 5 is clear to you. Right? Take a look at this. Every central public information officer or the state public information officer, as the case may be, shall deal with the requests from persons seeking information and render reasonable assistance to the persons seeking such information. Clear? So they are the ones who are going to be statutorily obliged to deal with the applications in a proper manner. They can't just brush off the application or say कि कर दो RTI हम देख लेंगे जो होगा सो होगा. They will have to give responsible answers to the application, right? So section 5 talks about the PIO. Section 6 talks about the request for obtaining information. Okay, so this is basically where you have what you can call the format for the RTI application. How do you file an RTI application is a question that is being asked over here. How do you file an RTI application? Okay, section 6. Okay, so just let me kind of briefly summarize things that we have studied till now. We studied section 3, which is given RTI a statutory status. We studied section 4, which allows you to have a what you can call the fact that all the documents and the records created by public authorities should be made in such a manner that they are accessible. Then section 5 talks about the fact that there are supposed to be public information officers, the PIOs, who allow you to take a look at the information properly, which is what their obligation is. And they are not separate officers appointed, they are the part of the same office, but the charge of the PIO has been given to one of the main people who has access to information. For example, in a bank it would be the manager, in a school it would be the principal, in a university it would be the vice chancellor. You see, the head of the organization who has access to all the information, that person will be designated as the PIO. Okay? The chart was not clear, please repeat again. Sure. This is the principal of a school. This is the vice principal. Then there are, let's say, heads of departments, HODs. And then there are assistant teachers. You see the point? This is a simple hierarchy of a government organization. What I'm saying is that if any kind of information is required from this school, okay, let's say a government school, if any information is required from this government school, let's say for example, they're not giving you a mark sheet. 4 months it has been since you have passed from the school and they're not giving a mark sheet, and you want to know why the mark sheet is not being given. What you can do is you can file an RTI, but who do you file an RTI to? You have to file it to the person in the government office who has been designated as a public information officer, PIO. So the principal, who is the head of the organization, is also holding the charge of being a public information officer. And once you file an RTI with the public information officer, which is the principal, then the RTI is going to be taken by the principal seriously, and the information which is available with the principal has to be given to you. Right? It is a legal right. It is what we call a statutory right of the principal to do it. You get the point? This is a statutory right of the principal to give you this kind of a activity and a documentation. Are we clear? Madan, do I make sense now? That is what section 5 talks about, the RTI in terms of the PIO. And then the next chart that I had discussed was very simple again. You have the PIOs who can be divided into categories, which are, for example, so public information officer for a central government organization will be known as a CPIO, Central Public Information Officer. For a state government organization would be known as a state PIO. For a uh, and the PIO can be assisted by a APIO, and a central APIO or a state APIO. This is very self-explanatory. If you have a central government organization, you will call the PIO of that organization as a CPIO. If you have a state government organization, you will call the PIO of that organization as a SPI. Right? Okay. I am, in a way, inviting you not only to learn something from the UPSC perspective, which you are, of course, doing it, but also to file an RTI, to know how an RTI works, gives you enormous power. You see, if you go to a bank and the people are not doing what they are supposed to do, and you feel that there is something happening which is fishy, just take the name of RTI and just make an impression that you know how an RTI is filed. All of them will get in the line to do your work without any chucha part. You see the point? Without any kind of a, whatever attitude they may be showing you, ye nahi karenge, wo nahi karenge. The moment you impress upon them, within a minute you will file an RTI. Okay, all of them will align to do your work, because the whole idea is that they will see you as a person who knows how to hold them against the wall under a statutory obligation. You see the point? So try to take this kind of a exercise not only as an exercise in terms of understanding something for the UPSC, but also empower yourself as to how you can deal with a government organization. And RTI is an extremely powerful tool in terms of the very mention of the RTI sometimes lets the government understand that they're not dealing with a layman. They're dealing with a person who knows how to empower himself with regard to governance in India. Right? It's an extraordinary tool. Okay, Biswajit has a question. Sir, is anyone can file RTI outside of the system, or only those people can file who are in the system? Any citizen in India. That's the point. See, section 3. Section 3. What does section 3 say? Subject to the provisions of the Act, all citizens shall have the right to information. Because all citizens have the right to information, it means systems mein, bahar, a person who is a citizen of India. Even if he, for example, doesn't have anything directly to do with the department, we'll see it later. If I am filing an RTI with a bank, I don't even need to tell the bank why am I filing an RTI. You see the point? I don't need to tell the bank that. Bank cannot ask me कि तुम्हारा क्या लेना देना इस चीज से. It cannot ask me the question as to why are you concerned with this information. Even if I have nothing to do with a particular government department, I can still file an RTI. That's the breadth of the scope which has been given to a citizen to file an RTI with a government department, be it a person within the system, outside the system, and not having to do anything with the system. I can go and file an RTI about something which I am not even remotely related to. I can go and file an RTI about a university in which I have never studied, in which I am not sending my children, which doesn't even belong to my city or my state, but I can file an RTI. And that is the whole idea of RTI activism, that people can file RTIs for different social causes and environmental causes, etc., etc., even if they don't have a direct relationship to it. So that's the breadth of the scope which has been defined under the RTI Act for the citizens to challenge the government in terms of getting the information out, right? It does not give you the right to prosecute the government officer, but it gives you the evidence that there is something which has happened which is wrong with the government department, and that kind of a thing can then be taken off, right? Maybe some of you will understand the whole Vyapam case, was the whole case about corruption in the admission of medical college seats in Madhya Pradesh, the Vyapam scam. Okay, all of that came out of a set of RTIs which were filed, and a lot of RTI activists were killed in this entire process. Okay, okay, so we take a look at this part. Oh, so I see all the questions over here. Mm, okay, all very interesting questions. Um, if the dealer of our PDS shop is doing wrong, what can I do against him under RTI? Excellent question. The dealer is generally a private person who's given a contract by the government. You have to go to the, let's say, for example, you have a Department of Public Distribution generally, which deals with the PDS. No, but it differs from state to state. So let me give you a simple flow chart of what you have to do. First, you have to get an understanding of which department is responsible for supplying the ration. Let's assume it is a ration to the dealer. Okay, find out which department it is in your state. This can be easy. You go to the PDS shop, don't try to appear hostile and ask him कि आपको कौन से विभाग से मिलता है राशन, which department gives you the ration to supply it. They'll tell you कि इस विभाग से. बोलो कहाँ है इसका ऑफिस, दफ्तर कहाँ पर है इसका, where is the office of this, they'll tell you where the office of is. Try to find out what department it is. This department will have the head of the department who will be the PIO. With him you file the RTI saying that I want a list of items which have been supplied to this dealer in what kgs. Let's say for example this dealer has been given 100 kgs of rice, 100 kgs of wheat, etc., etc. Find a list of them. Okay, once the RTI is answered, you will have a list which has been supplied. Then what you have to do is find out that if this person has been given 100 kgs of rice to distribute to the people, how much of it has been distributed. And if you find 70 kgs is one that has been distributed, you know that 30 kgs is gone, siphoned out in the middle. It is possible that this department with some personal private people in this department, government servant, and this dealer are in total involved in a corruption by which they are taking away the ration which is meant to be for the poor and then selling it off in the market. The rice of 30 kgs is being sold off in the market, and the money is taken by these people and distributed. This is a kind of a scheme or a kind of a scam which is going on over here. So you can get this kind of information once you very clearly understand and ask how much ration has been given by the government, and then you can ask that how much ration has the dealer given to the people. If these two informations don't match with each other, because he would create a kind of a tally, right, about how much has he distributed every day. He has to keep records and notify the government. So you ask the government both the documents: how much ration have you allocated and how much has been distributed, and for the remaining part which is undistributed, what is the status? Are you trying to distribute it? Are you planning to distribute it? Did it go bad? Did worms get to it? Did it go bad in rain? Did a roof fall over it? What happened? Give us the information. And if you see the asymmetry, very simply you can infer. It doesn't require a lot of Sherlock Holmes to deduce that अगर 30 किलो राशन बीच में गायब हो रहा है, the 30 kg of ration is being taken out in the middle. You are obviously looking at a point in which the government and this person are acting in some kind of a collusive practice of corruption. Okay, ठीक है. Just let me. Okay, I see a lot of interesting points that you're making, but I feel that we have to break now. This is a kind of a scheduled thing. Okay, let us take a break for an hour and come back and discuss these things. We'll be back by 1 p.m. Okay, 1 p.m. we will resume the class. Okay. Okay, thank you. I'm going to look at all the sections of the RTI coming forward and give you a better understanding and clarity of how you can file an RTI under section 6. If you have some spare time with yourself in the lunch, you can take a look at section 6 of the RTI Act, which is going to be a good way to start something to read on the RTI Act. This is basically the procedure by which an RTI can be filed, section 6 of the RTI Act. Okay? All right, we'll see you.